The 16-year-old suspect in a brutal double homicide has just been charged with murder, but in juvenile court. Could that change? Could he be charged as an adult? What would that mean? And we just learned new chilling alleged details from authorities that could change everything for this defendant. Welcome to Sidebar, presented by Law and Crime.
The affidavit reads like a police procedural written by someone who already knows the ending. On March 28, 2025, at approximately 10:11 a.m., officers with Saratoga Springs were dispatched to the address.
So, we have this affidavit for a search warrant for records and data that are associated with a Vivint security account for who appears to be Eli's father, electronic information, location information associated with seemingly a device or devices. And it reads, quote, on March 28, 2025, at approximately 10:11 a.m., officers with Saratoga Springs were dispatched to the address of a female had called 911 and reported that she had discovered two individuals unconscious and covered in blood at the above address. I have listened to the 911 call and heard the following. The caller, later identified as Lyman's daughter, Eli's sister, reported that she entered the above residence that morning after spending the night at her father's home in Cedar Hills and discovered her mother, later identified as Jessica Lyman, and younger brother, later identified as Eli Painter, lying in a bed, unconscious and bleeding from their heads. She also reported that the suspect, so then 15 years old, might also be at the residence. And yes, this 15-year-old, this then 15-year-old, currently 16-year-old, is Jessica's son. Horrifying.
A mother and her 8-year-old son found in a bed, both shot in the head. The mother still gasping for breath.
So the affidavit goes on to say that officers arrive, they find, quote, Jessica and Eli lying next to each other on a bed in the master bedroom. From the foot of the bed, Jessica was lying on the right side of the bed and Eli was on the left. Both had blood on and about their heads and faces, and blood was pooling on the bed below each one of their heads. Both appeared to have been shot in the head with small caliber round. Now, this is significant. A, state of the bodies when they're found gives you a timeline of when the shooting happened. The circumstances in which they were seemingly shot to death in the head, you can make the argument from prosecutors that this was intentional, right? That this was confined to a certain area. Now, the affidavit goes on to say that Eli apparently had no pulse, that he was cold to the touch, that rigor mortis had set in, that Jessica's, quote, shorts or pants were down around her knees, that authorities would later discover that her underwear was pulled down around her knees too. They also say that she gasped for a breath, that her eyes rolled into the back of her head. So one of the officers initiates CPR, EMS arrives, they initiate life-saving measures. She's transported to the Utah Valley Regional Medical Center, but in the end, Eli was apparently pronounced dead at the scene, and Jessica died 3 days later on March 31st. The officers start clearing the house, and that is when they find this 15-year-old suspect exit a bedroom door and enter the hallway. They sit him down, and he apparently asks what had happened, asks multiple times, claims he was in his room taking a nap, claims he didn't hear anything. And when asked, this is key, when asked if any weapons were in the house, he apparently said he wasn't aware of any guns inside the home. Now that's interesting, considering you think about the two victims here who were shot, and according to the affidavit, no one had told him at that point that anyone had been shot. Why is he mentioning guns? Now, a defense attorney can make the argument. You say weapons, quick association, guns. They search the home. They find two .22 caliber shell casings were found inside the master bedroom.
The boy already cold. And somewhere in the house, a 15-year-old exits his bedroom and asks what happened. That is the official record. That is the document. And here is the cognitive dissonance. The person asking what happened is now charged with making it happen. Before we go deeper into what the documents actually show, make sure you're subscribed to Trial Theory, Unsealed, because we don't just cover the story, we follow the evidence. Think of this case as a photograph developing in slow motion. At first, you see only shapes. Then outlines sharpen. Then details emerge that you cannot unsee. The affidavit says the suspect claimed he was napping, claimed he heard nothing. And then officers asked a simple question about weapons in the house. He said he was not aware of any guns. No one had told him the victims had been shot. That is a crack in the story, a hairline fracture that widens with every page. 2 caliber shell casings found in the master bedroom. A handwritten note referencing DNA and firearm testing. A second note that reportedly said, "This is a murder story." The evidence does not scream. It accumulates.
The technicians find what is believed to be seminal fluid on the bed. During the initial search, they also find apparently sex toys and fishnet stockings, both in Jessica's room and this then 15-year-old's room. They also apparently find panties in his room. Authorities also located in his room, quote, an empty Pilsner can in a dresser drawer, 2 BB pistols, plate carriers, and magazine pouches, and a, quote, handwritten note referencing several forms of forensic evidence. Specifically, the note mentioned serology, DNA, and firearm testing. Additionally, detectives located a note where this 15-year-old indicated that he wanted to kill himself.
Now here is the irony explosion. This 16-year-old, charged with aggravated murder, sits inside a system built for rehabilitation. Utah Juvenile Court has jurisdiction only until age 21. In some cases, secure care can stretch to 25. But then release is mandatory. 2 bodies, 1 defendant, and the legal question is not whether he did it, but which courtroom gets to decide what happens next. The state has announced its intention to certify him to adult district court. That is not a procedural footnote. That is the entire ballgame. Adult court means 5 years to life. It means the death penalty is theoretically on the table, though unlikely for someone this age. Juvenile court means a clock starts ticking the moment he is sentenced. And when that clock runs out, he walks.
So juvenile court only has jurisdiction over an individual until they turn 21. There are certain instances where they can keep them a little longer, or certain cases where then they may be transferred over to like a state prison system. But for the most part, most people aren't incarcerated in juvenile court, even in serious cases. They may do some time in some sort of secure care facility, but it's really geared towards being driven by juvenile probation, providing services to kids, services to families, education, treatment, those types of things to help get kids back on track. So that's why these cases where someone's charged with murder and they're a juvenile are so difficult, is the juvenile court only has jurisdiction for so long over an individual, and then, they really could only keep them in secure care, up until I think it's 25, and then they have to release them.
The gap between those 2 outcomes is not a legal nuance. It is a chasm. This could change everything for the defendant.
According to the New York Post, the prosecutors in this case say that it is, quote, the state's intention in filing this criminal information to bind the defendant over to the adult district court. So let me bring in Utah criminal defense attorney Sky Lazaro to talk about this. Sky, thank you so much for taking the time. This is an awful, awful case. There's a lot of components on it, but I want to start with what this whole juvenile adult court issue, because I think it's pretty significant. So how does it work in Utah whether this case will remain in juvenile court or adult court?
First of all, good morning, Jesse. This is a terrible, terrible case. Utah has a separate juvenile court for minors who commit even very serious offenses. As of right now, this kid is charged in juvenile court with murder and a number of other charges. It's really up to the district attorney's office whether or not they want to try to certify that to a district court. We do have a statute here in Utah that allows prosecutors to apply for a certification in really probably the most terrible of juvenile cases, to try those people as adults. There's a number of factors that go into it. The district attorney's office here said they anticipate doing that, although I'm not sure if those filings have been submitted to the court yet.
And that is the ticking clock moment. Because if this case stays in juvenile court, the countdown has already begun. Every hearing, every delay, every sealed filing, they all burn time on a limited fuse. What happens when the system built to rehabilitate a child is asked to contain someone accused of executing his own mother and his own brother?
And they are completely separate and completely different. Juvenile court is a bench trial before a judge. They still have the same burden of proof, but actually they don't make guilt findings. They just call them, findings essentially of what happened. Versus, and you don't have the option of having a jury trial in juvenile court. It's a closed proceeding. It's not open to the public. Everything is sealed, like nothing is available to the public essentially that happens in juvenile court. Versus when we look at adult criminal court, we're seeing, these trials that are being live streamed as they're happening. Everything is open to the public. You have a jury, or you can elect a jury or a bench trial. So they're very, very different. The rules of evidence are largely the same, but the juvenile court has its own body of administrative governance as well. So there's rules that apply in juvenile court proceedings that may not apply or apply differently in adult court proceedings.
That is not a rhetorical question. That is the central tension of this entire proceeding. Now, the parallel narrative. While the court decides where this case lies, the evidence continues to speak in a language that requires no translation. Surveillance footage from neighboring homes shows a figure moving between 2 and 3 in the morning. Black and white mask, dark hoodie.
The video shows a suspicious individual who appears to be wearing a black and white mask, a dark hoodie, shorts, long black socks, and possibly slip-on shoes or sliders. This individual appears to be walking through the neighborhood while clearly trying to avoid motion-activated Ring doorbell cameras. The suspicious person is seen walking into the breezeway immediately north of the residence where the incident occurred. In one of the first videos where the suspicious person is observed, it appears as if the individual is wearing a backpack. Why is that significant? Well, later on April 13th, 2025, according to the affidavit, a couple that was walking their dog in the area find a backpack. They call police. Quote, Officer Sorensen found the backpack was located in reeds a few feet from a walkway through a riverfront park area that is accessible to the public. Officer Sorensen did not observe anyone who appeared to be looking for the backpack while she was there and suspected that the backpack was abandoned or had been discarded there. Looking inside the backpack, Officer Sorensen saw what she thought was a dark hoodie and rubber gardening gloves. Officer Sorensen noted a red dried substance on the gloves that she believed could possibly be dried blood. Detective Morgan also observed a red, rust-colored dried substance on the rubber gardening gloves that could possibly be dried blood. He observed that there was also a black beanie-style hat, a small flashlight, a headlamp, and a black neck gator-style face mask that had a partial white skull jaw printed on it. Upon more closely inspecting the contents of the backpack as well as the backpack itself, he noticed that it appeared to have a large amount of animal hair throughout the backpack and on many of the items. This animal hair was similar to the cat and dog hair that was found throughout the residence where the homicide occurred. Furthermore, the black beanie-style hat also contained what appeared to be human hair on the inside of the hat. The mask also appears consistent with and/or looks similar to the mask worn by the suspicious male seen on Ring doorbell videos walking through the neighborhood on the morning of March 28, 2025.
Sliders. The figure avoids motion. Activated cameras. A backpack recovered weeks later near a riverfront park contains a dark hoodie, rubber gloves with what appeared to be dried blood, a black beanie with human hair inside, pet hair matching the home, a single right-footed slide slipper, the left one never found.
On April 23, 2025, detectives served an additional search warrant at the residence where the homicides occurred and found and seized several pieces of evidence. One piece of evidence was a single right-footed black Nike slide slipper. Detectives have observed the 15-year-old wearing these shoes in multiple pictures found on his phone, and they appear similar to the shoes worn by the masked suspect seen walking through the neighborhood on various doorbell cameras. Detectives believe that the 15-year-old and or a family member might have removed the matching left shoe. Going back to the suspect, the affidavit states, quote, "Through search warrants obtained for his Discord activity, we have learned that he has access to an old Samsung tablet that he is using to communicate with friends through the Discord app. Furthermore, detectives have learned that he has communicated with friends and discussed the homicides with his online friends."
Each item is a breadcrumb, but together they form a trail. And then there is the audio. Home surveillance captures a woman's voice screaming the suspect's name. "What are you doing?" Less than 2 minutes later, 3 gunshots. That is not circumstantial. That is sequence. That is
something
timeline.
else. It is being reported by ABC4 that the suspect, now 16 years old, was examined by police, that they determined he had scratches on his right shoulder, that his DNA was found under one of the victim's fingernails. Now, a defense attorney could say, hey, they live together, it's not unusual. But also, the outlet is reporting that his DNA was also allegedly found on the shorts that Jessica Lyman was wearing. We've talked about that before too. That the seminal fluid found on the bed, which we mentioned before, allegedly contained this suspect's DNA. The outlet also reports that gunshot residue, GSR, was found on multiple items of clothing associated with the suspect. And then there's this, according to the outlet, that home surveillance footage from a nearby home captures an argument or altercation on March 27th with a woman potentially consistent with Lyman's voice screaming this 16-year-old's name and saying, "What are you doing?" And that less than 2 minutes later, you can hear 3
And
gunshots.
yet the defense will say the voice could be anyone. The figure could be anyone. The backpack could belong to anyone. The beauty of the adversarial system is that every fact gets challenged. The horror of this case is that so many facts already align. But here is what the procedural battle masks. The text messages recovered from Jessica Lyman's phone reveal a relationship that was already on fire months before the shooting. July 2024. A mother telling her son, "I wish I died in your stomach."
And then I got to talk about the text messages. On April 2nd, police apparently got some critical evidence from a forensic download of Jessica's phone. And they found a text message exchange or exchanges between Jessica and her teenage son from the summer before, so July 2024. Many of these messages are just too vulgar to repeat here, but I'll give you an idea. Here are a few. Quote, "I don't like you, go away. Do you need to learn how to shut your mouth? You're so bleeping mentally ill. Do you know how insignificant you really are to my life? Very insignificant. I wish I died in your stomach. Wouldn't have to put up with you."
Telling him he is insignificant. The defense will point to these messages not as justification, but as context. Mitigation, the foundation for a mental health defense that could reduce charges or shape sentencing.
Given what we know, which is very, very limited right now, I think there's a possibility, or a pretty good possibility, that this case could get certified to the district court. Like I said, we're not privy to this kid's mental health records or what was going on in the home or other mitigating factors that would, lead a court to want to keep this in the juvenile court proceedings for those types of reasons. But given what's been put out there and what information we have, I could see this being certified.
Okay, so now let me ask you about a defense here. He is innocent unless proven guilty.
Mm-hmm.
But I just laid out in my intro all the alleged evidence that they seem to have right now against him. And gunshot residue, notes in the room, text messages, surveillance footage, forensic material, alleged communications, eyewitness testimony. It feels like a lot. If you were defending this case, where do you begin? Does the first thing you try to do is to make sure some evidence doesn't even get into trial in the first place? And What evidence would that be? What arguments would you even make?
I think with every case, you start there. You take a really close look at the procedural analysis of all the evidence collected in the case. How is it collected? How is it stored? How is it tested? All of the things that you can pick apart from just a pure procedural. They didn't follow the rules standard. They didn't follow the rules on a search warrant, things like that. So there's always arguments to be made there. Assuming, and that takes some time. Do we need to retest things? Are there other things that need to happen in this case? Assuming all of that is not problematic, and it's coming in, I think this is probably one of those cases where you start looking at a mitigation type defense. How do I get my client through this if I can't keep any of this evidence out? Because the evidence, the way they've stacked it up, at least in the probable cause statement they filed, which, I mean, we all know those are all of their greatest hits. They're not going to put anything in there that's detrimental to their case. It's going to be their strongest evidence, right, that they have right now. So assuming that all of that is true and you can't challenge it or you can't keep it out, I really think this becomes a mitigation case where you really have to start looking at this kid and what can you do to get him through this process and still come out the other side without spending the rest of his life in prison.
The
Do you
prosecution
mean
will point to them as motive. The same words, read by two different sides, become two different weapons. This is where the case turns. Not on what happened, but on what the happening meant. And that moral refrain keeps resurfacing. The evidence accumulates. The evidence accumulates. The evidence accumulates. Blood, gunshot residue, DNA under a victim's fingernail, sanal fluid on the bed linked to the suspect, scratches on his shoulder. A forensic portrait, so dense it feels less like an investigation and more like an inventory. Yet none of it answers the only question that matters. Why? Why would a 15-year-old allegedly shoot his own mother and his 8-year-old brother in their bed? What breaks inside a person to make
text
that
messages?
possible?
But I think that this new revelation about this audio, right, the surveillance footage capturing this audio of a woman who, arguably could be Miss Lyman saying, "What are you doing?" saying his name, and then the gunshots right after. You couple that with some of this forensic material that has been linked back to him. I think that this is why I think it's a strong case from the prosecution. But I don't know. To me, that seems the part that there's one aspect to say, well, how do you know that's really him in the surveillance footage? Make and build the same. The backpack. They tried to link the backpack back to the room. But I think it's that audio that is going to be really, really strong for the prosecution. Do you agree?
I do. I think the audio is going to be hard to overcome, especially like you highlighted where she says his name. It's clearly there's something going on at that time, and then we hear the gunshot shortly thereafter. That's going to be, some of this is circumstantial evidence, that the surveillance video and what juries want to make of that. But anytime you have a video or an audio captured in real time of what's happening, and you have the defendant identified on the video, you hear their voice or they say something or somebody says something to them or calls them by name, that's usually really strong evidence, and it's really hard to combat that evidence and to counter it or to come up with some sort of other explanation. Because he said in his statement, he said he was sleeping and he didn't hear anything. And so, his mom yelling at somebody else, there's arguments to be made there. But it seems, at least the way it's presented, that I think that is probably fairly strong evidence for the state.
And
The
I'm sure
court will answer the legal question, the procedural question, the jurisdictional question. But the human question remains outside the record, unsealed, but unresolved. So here is your call to research. Go pull the actual search warrant affidavit filed in Utah County. Read it for yourself. Not the summaries, not the headlines, the document. And then ask yourself one question based solely on what is in that filing. Does the evidence support certification to adult court? Or does the defendant's age and mental state demand that the juvenile system retain jurisdiction? Answer that in the comments. And if this channel gives you the kind of legal analysis you cannot find anywhere else, like this video, share it, subscribe to Trial Theory, Unsealed, and turn on notifications. Because the next filing could change everything.